What's up, everybody? It's Stephen Williams, founder and president of the creditrepairshop.com. And in today's video is question and answers. We got so many of them coming in that I got to do it this way. But I did get surprised by something in my email box today, which was kind of caught me off guard. They usually wait till the end of the week, but maybe because of the holiday, they're sending out made an for 747,000, a group of national, it's payday loans, uh, 542 accounts, average balance $1,379. They made that available. Um, Mixed lenders, average charge-off date 2009. And then there was another group that came, for, let's see here, $5 million, and this is a mixed group of credit cards. Let me turn this app off on my computer. Um, you always know the standard thing that we do when you get a demand letter from a debt collector. You need to respond to it. If you don't respond to it the right way, you're gonna open up the door and allow them to come at to, number one, place it on your credit, and then number two, to, if they choose, start the process to try to summons you to court for that debt. It happens all the time. People always wonder, how can a charge off debt or written off debt end up coming, uh, buyer end up coming after me, suing me. I thought because they wrote it off and they wrote it off on their taxes, that the money was just all of a sudden not owed anymore. That's not true. 100% not true. And but what is true is that you have a way of fighting them, and the first line of defense is to make sure that the debt that they're trying to come after you for isn't past the legal statute of limitations to collect debt in your state. As a matter of fact, for most credit card companies, and that's considered an open account. And you can go to my website to see what your state statute of limitations for collecting debt is. But in my state, for a credit card, which is an open account, it's only 4 years. Regular debt is 6 years. So you can go to my website, thecreditrepairshop.com. The link is right here on the video or below the video, and you can type on my blog statute of limitations, and you can see what your state statute of limitations are for debt, for being able to legally collect the debt. Now, this is debt that is not a judgment. This is a debt where they still have it, either the debt collector or the original creditor still has it. They haven't done anything with it. They haven't taken you to court and got a judgment. You cannot, potentially you may not be legally obligated to pay that debt. I'm giving you two free letters. One is the statute of limitations letter, so you can notify them. You can't just say, I'm not going to pay this debt, or you're not going to just be able to just disregard the debt. You need to let them know that you know legally that you don't have to pay the debt, and they will leave you alone. The next thing is the debt validation. If the debt is not past the legal statute of limitations, then you need to send them a debt validation, and this will work only if it's with a third party debt buyer like the ones I just talked about here. These are mixed credit cards and payday loans that are 2009 charge off dates. Most states, only one state goes past 10 year. Only one state goes past 10 year. All the rest, if you were to receive a demand letter to pay from one of these debt collectors, you would not be obligated to legally pay, but you have to know your rights, or you're going to end up, resetting that debt for another period of time for your statute of limitations in your state. So get the letters right here. You can see below this video, the link is below. I do ask for a donation. I think it's worth it. because I spend a lot of time here giving this information to you here on YouTube. Now let's answer some questions. 63-year-old said that lost her job and received a letter from a charged off debt. Here we go, right here. Received a letter about a charged off debt. They're coming to the door, which they're knocking on the door. That means that they're probably trying to summons this individual to court. And this is what you do is you need to answer the door, accept the summons, because just because you don't accept it, just because you don't get served, all they have to do is prove that they attempted to serve and they'll be able to proceed. That's all they have to do. They're going to post it in the daily newspaper or a weekly newspaper. They're going to put a notice on there. And if you don't see it, you don't see it. That's all they have to do. And they're going to end up getting default judgment because of your situation. You said that you're not working, you're 63 years old, you lost your job, can't pay. I guarantee, I don't want to say I guarantee, but if you notify them of your situation, they may choose to either shelf the lawsuit or to not even go after it at all. These people are in the business of making money, they're not in the business of spending money to get no money. So that's the answer to you on there. This one here, what to do if you go to court, if you get a court summons for collection. Uh, well, I guess they really wasn't saying anything. Here's another question. Oh no, this is someone. Thank you for saying that I uh, care about people. Thank you. Here's one. What if I'm being sued in New Jersey, but the account was created in Florida, and I also live in Florida? What do I do? I am being sued. Number one, when they file the lawsuit, they must file it in the area that you live in. But they can get away with it if you don't notify. So, using that court document, you notify the judge that they are not servicing you in your area. So that's what you need to do. Notify them, because if you don't, they're going to get a default judgment in New Jersey. They're going to do what's called a foreign transfer to Florida, and then you're going to be like up the creek. Trust me, because this happened to me. I lost $43,000. I made a $43,000 mistake, and I personally had to pay a $43,000 settlement on a foreign judgment that was against me. And so don't make the same mistake I made. Contact the New Jersey courts on the document. You obviously know that you're being sued, so contact them. Let them know that you do not live in that state. They will make them refile it in Florida. Let's see, receive notification, and I still have my car. They did not come and get it, but it never could because my husband was at work. Do I need to send a demand letter? I received a notification. I guess, are you saying that you received a notification that they're going to try to get the car, or you received a notification that they're going to give you your title and pay off the car? I'm not sure on that, but if you receive a notification that they're coming to get the car, if you don't want to give them the car back, you need to find out, number one, if you're on the list. They are 100% in control of who is on the list and who's not on the list. That's just the way the settlement was written. Santander is 100% in control. But what you can do if you're not on the list, you need to file a complaint with your consumer department with them. And when you file that complaint, you need to put on there that you're being that Santander's debt collection department is coming after you, not Santander. This is something that we figured out last week. Is what Santander is doing is they will say that they're not actually calling you about the car, that they don't even have the account anymore. But guess who has the account? They're the collections department. So what they do is they send a letter to you notifying that they are decollateralizing the automobile loan, which allows them to place that loan, that the balance of that loan into a debt collection status, because they wouldn't be able to do that if they still had the vehicle. That's why when you actually have a vehicle repoed, They don't even come after you for the money when they first get the car. They have to sell the car and then come after you for the uncollateralized debt that's owed on the vehicle. Okay, the next question here. What if you settle with the collection agency for an account that was a charge off? See, that proves that you can end up paying a charge off. I hope you did validate it and made sure that it wasn't past statute of limitations for your state. And they did not remove it. What you do is you just continue uh, uh, disputing to get it removed. You can either get it disputed and placed as positive information because they actually didn't own the account. So listen to this. Listen to this strategy. All the YouTube credit repair people are going to try to steal this. Listen to this strategy that we use. Um, if you pay a collection off and the collection agency refuses to negotiate to get it removed, usually they'll want to get more money to get it removed. So what most people do, or they may say that they can't get it removed for whatever reason. They just don't want to even discuss getting it removed. Let me tell you the reason why on that is that uh, they they get charged for every line of data that they place on reports and all the lines of data that they remove off of reports. So it's in their financial interest for them not to have too much data on there. The bureaus make them pay a membership and they charge them per line of data. But let me tell you the strategy. You could either force them into putting this whole account into positive status and it'll actually make your credit scores move up. And let me tell you why. Because you were never behind on any payments to that collection agency. All they had was an account that they assumed. They never sent you any bills or any statements for any types of payments. So you can actually say that you want them to list that this account is 100% positive. And you can easily do that by sending them, well, disputing through the credit reporting agencies that it is not being reported accurately. Um, th- th- this is something that we've done with accounts, and you'll see that debt collection companies start having the green placed on there because uh, either they're gonna have to remove it or they're gonna have to place it as a good account because you were just in a dispute process with them, and now that you resolved it, they have to place that as a positive account. They can't just say that a collection account anymore. Next thing, someone they receive forgiveness on their Santander automobile. This was on their loan. This was just 2 days ago. So they're still slowly going through the process of doing this with everybody. Let's see. Let's see. Someone said that they're starting to pay off their Capital One cards. Start paying off my Capital One cards that were charged off. Even though I'm only making $10 payments here and there, they started reporting that. That's what I just said that just only just a few minutes ago, and the scores started raising. So that is something that you can do. Even if it's still held with the original creditor and they charge them off, which is kind of crazy. I don't think you're actually paying Capital One. You might be, but if it's charged off, well, potentially you could because things have been kind of strange with what they've been allowing people to do. They've been charging off and then they'll still let interest go, but you can pay that credit card. They can cancel your credit cards and still require you to pay the credit card company, even though you don't have that open account anymore. They consider it a closed account. It's not an open-end credit account. All right, I think that's going to do it for this group of questions. I'm going to do some more answering the questions over the next few days. And I hope everybody have a good day and continue working hard to get where you want to be with your credit. Uh, Remember again, if you need help with your credit, please visit our website, thecreditrepairshop.com. Please watch the video, What Makes Us Different. If you can follow what I say in that video, then please sign up as a customer. If you can't do what I state in that video, don't sign up as a customer, because credit repair is a process. It's not like ordering McDonald's and you're going to get your order, in 5 days or in 5 minutes, like you do when you go to McDonald's. It's not going to be that way. It's a process. And with what's going on with COVID, they've been giving the bureaus a lot longer time to respond, and are not requiring them to respond by mail all the time like they used to. But they do update in the credit monitoring services accounts. If you haven't subscribed to the channel, please subscribe. Please post your comments. Please ask your questions. Don't forget to get the free debt validation letter. It's below. Link is below here. If you're being sued and you've been sued by a third party collector and you want to get a defense package made for you, at least you'll have a chance. Not saying that you're always going to win, but at least you have a chance. There's a link below this video also for that program. All right, thanks again. This is Stephen Williams, founder and president of the creditrepairshop.com. Thank you, and until next time.